My new phone has stopped working and the seller says it is my fault. But I didn't do anything to the phone. It suddenly stopped working. It must have been defective. I don't want to go to the court. It will cost more than the price of the phone in legal fees and it also takes time.
Calm down. Where did you buy the phone from?
I bought it online from a supposedly reliable merchant.
Online? Then you can try online dispute resolution.
Online dispute resolution? What is that? Does it involve the courts?
Oh, what a coincidence. It is now on TV. Look.
Sounds interesting. But what is it all about really? I suggest we discuss it over lunch.
ADR does not involve the courts, hence the reason why it is called alternative. It can take various forms, including arbitration and mediation.
To be honest, I have never understood the difference between the two.
Don't worry. Both involve an independent third party who undertakes to hear the parties in dispute. The mediator only proposes a fair solution without issuing any judgment. On the other hand, the arbitrator issues judgment against or in favor of one of the parties similarly to what a judge does, albeit without the costs and delays of the justice system.
But how do I know that this independent third party is trustable, impartial and fair?
This is a main role of the EU Directive on Consumer ADR. The legislation lays down strict conditions that should be met by ADR entities and the natural persons offering the dispute resolution service. Look at this note on my phone.
Understood. The directive also makes sure that the procedure will be conducted fairly too?
Yes, relevant fairness requirements in Article 9 seek to ensure that both parties will be treated equally and be given the chance to present their position and arguments to the independent third party. Also, they have to be informed about their right to seek legal or other independent advice, as well as of the outcome and its main grounds in writing. Additionally, they must be informed of their right to withdraw from the process, when this only seeks to propose a solution, if not happy with how it is conducted. In such cases, they must even be told about their right not to accept the proposed solution and seek judicial redress, thereby trying to secure a different judgment. The parties must be given enough time to consider whether to accept or reject a proposed solution.
Sounds that the EU legislator has done a good job. Yet, I still have so many questions. How can I find an ADR entity that meets all of these requirements? Also, how do I go about submitting a complaint?
As a result of Article 20, all approved ADR entities in the various member states are listed publicly by each national competent authority and by the European Commission on its website. These are the entities who have submitted themselves to a check by the competent authority against the criteria of independence, impartiality, quality and fairness laid down by the directive. As for the formalities and procedures regarding complaint submission, you can find all relevant information on the website of your chosen ADR entity. Article 7 lists detailed transparency requirements that ADR entities should meet. These require that they maintain a website with all the information a consumer needs in order to submit a complaint to an ADR procedure. It is important for consumers to review the website of the ADR entity carefully. Indeed, There may be a deadline within which a complaint must be submitted, or an entity may not accept complaints that concern a very low value or have not been submitted to the trader first. ADR entities are free to set out such rules or restrictions.
Great. I will have a look. But some questions are pressing. Is it free? Fast?
It may be either free or involve only a nominal cost for the consumer, such as €20. The parties need not be represented by lawyers and can therefore save on legal fees too. And it is really quick. The procedure must reach an outcome within 90 days. Judicial proceedings usually last for years. It is worth mentioning that ADR entities must make dispute resolution available both online and offline. These form part of the requirements of effectiveness contained in Article 8 of the Directive.
Wow. But what about the significance of the outcome? Is it binding upon the parties?
It can be binding, yes. But only if the binding nature of any solution is brought to the attention of both parties beforehand, and the parties have accepted it. Article 10 of the Directive says so.
ADR is mandatory.
This is a very good question actually. It is voluntary for consumers. For traders, national law may render participation to ADR mandatory, something which would greatly help remedying one of the main problems, namely, the low trader participation rates. In any event, when the trader commits or is obliged to subject itself to an ADR entity, he is obliged to inform consumers about the entity or entities to which he subjects, together with a link to the website of that entity or entities. This information duty is contained in Article 13 of the Directive.
Thank you so much. It is a pity that Consumer ADR pursuant to the relevant directive only concerns cross-border disputes though. Most consumers buy from merchants established in their own member state.
No. The Consumer ADR Directive applies both to cross-border and domestic consumer contractual disputes concerning goods or services. It is not like the Small Claims Regulation, which lays down a fast judicial procedure for cross-border disputes only.
Oh, that is really good. Don't you think, however, that consumers may refrain from resorting to ADR in order to avoid risking their claim barred by national statutes of limitation? This risk is serious, especially when the ADR outcome is not binding upon the parties.
Fortunately, there is no such risk. Article 12 specifically addresses limitation or prescription periods, ensuring that a consumer will not be prevented from resorting to the courts if ADR resulted in no remedy for him. At national level, this is usually achieved by a provision in the law, putting any limitation periods on hold pending an ADR procedure.
Okay, I have to admit it. Consumer ADR has all the makings of a promising alternative to judicial dispute resolution.
At long last. It took me a lot of time to answer your questions, but it has been worthwhile at least. I have to go now.
Wait! What about ODR?
I am tired. You can search for information on the EU Consumer ADR online. There is plenty available, amongst others, on the official website of the European Commission. Here is a link.
But you are describing everything so nicely. Can we meet tomorrow for ODR, please?
I have a better idea. I will arrange you a meeting with an ODR expert. She will be able to answer all of your questions.
Yes! Thank you so much. Bye-bye.
Hello, Honk. I am happy to fill you in with the details regarding EU online dispute resolution. However, following the long discussion with Lizzie on alternative dispute resolution yesterday, this will be a piece of cake for you.
Yes? Why is that?
This is because the relevant EU regulation does not in fact establish a thorough dispute resolution system, and does not lay down rules governing the substance of the process either. Rather, it establishes a technical platform via which the dispute resolution procedure can be handled online, with the coordination of complainants, respondents and ADR entities. It also lays down certain procedural requirements necessary for this online handling and coordination.
And it can be used in relation to all consumer disputes involving goods or services, just like the directive on ADR?
Actually not. Online dispute resolution under the regulation is not only handled online, but also covers disputes arising from contracts concluded online. Accordingly, disputes arising in relation to offline contracts are not subject to the online dispute resolution procedure of the regulation.
Okay, what is the relationship between the directive and the regulation then?
The approved ADR entities subject to the directive are registered with the platform in order to be assigned the resolution of consumer complaints, when these fall within their competence. They don't have to handle the procedure on the platform, and can thus use their own infrastructure, but need to respect the directive's 90-day deadline within which to reach an outcome. Is this clear, Hunk? I am sure you have some more questions for me. Perhaps you are wondering what is the exact role of the platform?
Right, thank you.
It operates as a complaint submission, translation and transmission facility, as well as a tool of support for the parties, guiding them through the process, informing them of available competent ADR entities, and more generally, aiming at ensuring that the complaint is to be received by the party against whom it has been filed, and that the parties will be informed about the need to agree to an entity within a 30-day time limit. Thus, an online complaint form that is to be filled in by the complainant is a central component of the platform. Of course, the platform also serves as a source of information, such as general information on alternative dispute resolution, the ADR entities subject to the relevant directive, and statistics regarding the use of the platform and the outcomes of the disputes resolved through it. Article 5 describes the aims and functions of the platform in detail. And you can also have a look at the platform at this address.
I will definitely do that. I am curious though. All of this support is provided by who? Also, any information duties imposed on the traders to spread the word about the existence of this platform?
I am impressed with you. Indeed, by virtue of Article 14, online traders must display on their website a link to the platform. As for who lies behind the platform, you can have a look at Article 7 of the regulation. All member states had to establish relevant contact points with knowledgeable advisors who can guide the parties with regards to the use of the platform, and even advise them as to other dispute resolution options when their dispute has not been examined through the platform. There are several reasons why this can be the case. A competent entity may not exist on the platform, or one such entity may not accept to take up the case. Additionally, the parties may fail to agree to an ADR entity, or the trader may omit to reply to the submitted complaint proposing an ADR entity.
Doubtless, the EU take consumer alternative dispute resolution seriously. Thank you very much for this discussion. I now feel I know all basic aspects of EU legislation on alternative and online dispute resolution relating to consumer contracts.